Jack Hall asked Harriet to explain the Smith Act trials to Union members. On the island of Hawaii, 180 miles from the federal court, she delivered a rousing speech.
There is no such thing as a fair trial in a Smith Act case. All the rules of evidence are scrapped or the government can't make a case. They just make up rules as they go along.
A reporter for the Hilo Tribune-Herald wrote a story about the event and included her words. 2 days later in Honolulu, Judge John Wigg, the presiding judge in the Smith Act trials, called her before the court and questioned her about her statements.
I recall clearly that I did say there is no such thing as a fair trial in a Smith Act case. The reason was that years of propaganda which preceded the enforcement of the Smith Act have created such an atmosphere of hysteria that the very word communism has become a deadly label that is almost impossible for jurors to put out of their minds. And may I say, Your Honor, that my remarks were directed primarily toward the conduct of the prosecution. And of course, more learned and prominent people than I have said much stronger things.
The judge ordered a further investigation, and in 1955 the Territorial Bar Association filed a complaint with the Territorial Supreme Court against Harriet for unethical conduct. The court ruled against her, and on April 16, 1956, ordered that she be suspended from practice for a year. This suspension virtually equaled disbarment. Not only would she be required to take the bar exam again, but to be reinstated, she would also have to satisfy the territorial bar, her prosecutors, as to her good moral character.
Never. The Big Five would never let them give me my license back.
The goals of the people who had brought the case was to destroy the labor movement by trying to destroy those who were in service to the labor movement.
It's unbelievable to law students today reading In re Sawyer that she was disbarred for making this speech, but she was. You have to remember who was deciding who gets disbarred in those days. It was the same people who were running the Big Five companies. Their lawyers were running the bar.
Meyer Simons and John McTiernan, a Los Angeles attorney, appealed Harriet's case to the Ninth Circuit Court. Harriet was allowed to practice law while waiting for her case to be heard. The Ninth Circuit Court ruled against her, 4-3. In a classic illustration of chauvinism, it chastised her for her lack of humility. But in his dissenting opinion, Judge Walter Pope warned that the decision served notice on all lawyers to hold their tongues in case some court decided that criticism of a prosecutor's procedures could be grounds for disbarment. Disheartened but not defeated, Harriet made plans to appeal to the U.S. Supreme Court. Harry Bridges, her longtime friend and mentor, tried his best to talk her out of it. The Hawaii 7 convictions had already been overturned. He tried to persuade her to cop a plea, to try to save her license, but she stubbornly refused. The United States Supreme Court heard her appeal and decided in her favor on June 29, 1959. The majority opinion stated that a lawyer's criticism of the rules of evidence does not constitute an improper attack on the judge, and pointed out that appellate courts find judges wrong on matters of the law daily.
In the history of the legal profession, it's very important because it's the case that establishes the free speech rights of lawyers. And you see it all the time. When the trial is over, they go out and they talk to the press and they express their views. They have the right to do that because Harriet established that principle in American law.